is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Then please consider subscribing to my channel. Hey everybody, welcome back to J is for Justice. No intro today. I'm just right into it. How are you guys doing? Welcome back. Welcome back. We've got a lot of documents to go through tonight. So I hope you're in it to win it with me. Bryan Kohberger trial. I don't think there's going to be any delay in Bryan Kohberger's trial because it looks like everything is going forward. The judge is pushing everything forward. It doesn't look like he's going to allow any delays. So I found it interesting when I was looking at that the trial starts on August 11th and is slated through November 6th. So if you think about November 6th, it ending, and then what? Verdict watch for how many ever days or weeks? We may have a verdict on the anniversary of the murders. Did you guys ever think about that? What's up, Chris? Hey, Northern Beans. Melissa Hart, thanks for joining. Hey, Sarah. We've got Nash Native and Chris and Cheryl. Thank you for being here tonight. So, yeah, won't that be kind of monumental if they get a verdict on the day of the anniversary of the murders? Hey, Butter. All right, well, let's start going through these documents. This is awfully bright. I got my big screen, and it is white. You never watched a trial that was that long? Oh, God, I don't think I have either. Like live? No. Maybe replaying, OJ or something, but... Anyways, let's get into it. So we're just going to start clicking through these because there's little nuggets hidden in each of these documents sometimes. Sorry, my dogs are barking at something. So we're going to start with June. Let's see, where did we leave off? Motion to seal. We're going to start on the 5th with this order and see what this is. Because I think that's about where we left off. Hey, September. Hey, Ministry. Good to see you guys. Come on in. Come on in. And then we have a little video we're going to watch as well. Sorry, we're trying to get the dog to calm down here. So that's just an order sealing. Motion for permission to exceed page limit. So this is the state coming through. Due to the fact that the defendant's motion is 40 pages in length, the state's response will be about 17 pages with a 5-page appendix. Moving on. State's opposition to defendant's motion to continue. All right, so this is where we get into it here. Let me make this bigger so you guys can see it. How's that? Thank you, AJ, for being here. I appreciate it. All right, so this is the state's opposition for the motion to continue. It says, it is time to try this case. Defendant was arrested in late December of 2022, was indicted of May of 23. He successfully moved to transfer venue to Ada County. In October of 24, this court entered its scheduling order setting deadlines for pretrial motions and expert disclosures. And if you remember, Ann Taylor was asked last fall, do you need any more help? She's like, no, I don't. Like, I'm all good. Hey, Kels. She's like, no, I'm good. Now she's saying she needs more time. I don't think she's going to get it. I don't think it's going to happen. Defendant complied with the deadlines without moving for a continuance, including by disclosing 6 expert reports for the penalty phase, disclosing over 21 pages of purported mitigation materials, listing 55 penalty phase witnesses. 55 for the penalty phase. Hey, Shell. 55 penalty phase witnesses. Wow. And identifying 132 exhibits he may introduce during the penalty phase of trial. But now, after all discovery deadlines have passed and after the court conducted the pretrial conference, defendant seeks a trial continuance of unspecified length. He bases his request on his claim that the mitigation investigation is incomplete, while the state is unable to see whether defendant's ex parte filing contains specifics. His motion does not. Defendant has not shared what new evidentiary materials he seeks to obtain or how additional investigation will actually produce them. So they've given no information. They're just saying, we need more time to do this, that, and the other, but we're not giving any specifics. While defendant is fully entitled to due process, this court should exercise broad discretion to deny the defendant's 11-hour motion. First, defendant cannot show good cause or prejudice. Even under the heightened, non-binding ABA standards he seeks to impose on the court, his counsel's resources in investigation to date have been adequate, even setting aside that the defense team still has more time to prepare its mitigation case. The court should also give these victims' rights substantial weight in covering the motion. Finally, while the publicity surrounding the trial is a challenge, defendant has not shown and cannot show that continuing this trial will make things any easier. It is just as likely that delay will make it harder to seat a jury. Okay, so they're going over these scheduling deadlines of January 2025, March 3rd, and June. In June, they disclosed they had in discovery over 2,500 photos and videos, over 3,500 pages of investigative materials, and many megabytes of electronic data related to the guilt phase. They have amended reports from Dr. Orr and Dr. Ryan, and reports from 4 additional experts, 3 of whom are behavioral health neurology specialists. They also disclosed 2,100 pages of reported mitigation materials and the 55 defense witnesses. And we talked about all that. Then they go into case law. Let's go down to the conclusion here. This is about the experts. So remember we talked about earlier in a filing how they went so deep into his life? The victims in this case, including the immediate family members of the homicide victims, have a right under Idaho Constitution and timely disposition of this case, given that it has been nearly 2.5 years since the defendant's arrest. The victims' rights and their desire, they do. I mean, they want it over. Okay, here's this about Dateline. There is no doubt that the publicity surrounding this case, including but not limited to a recent Dateline show, contained non-public evidence, poses challenges for the court and both parties. The state reaffirms its commitment to comply with the non-dissemination order. However, the defendant's reliance on the Dateline episode to support his motion is misplaced for several reasons. First, the question of whether the defendant can receive a fair trial is not answered by the amount of and the nature of pretrial publicity. Rather, it depends on whether a fair and impartial jury can be seated. Here, venue has already been moved, and the court will use a much larger pool of potential jurors than in the defendant cited cases. So they're basically saying they can get a fair trial if they are able to question the jury members. It says, in this light, it is relevant to continue or consider how the specific jury pool at issue, which consists of citizens from Ada County, may or may not be impacted by media coverage. Local media is likely to continue to consistently report on this case regardless of the trial schedule. The November anniversary of the murders, for example, generates stories. So that's that. We have here table 1. Let's see what this is. Medical history. This is in the defendant's exhibits. It's addressed in multiple expert reports. Family members can also testify about this topic of medical history. And the defendant, any missing medical records have been available to the defendant. Complete prenatal, pediatric, and adult health information. This is also in their exhibits. It's addressed in multiple reports of mental health professionals, and the family can testify. Exposure to harmful substances in utero and in the environment. No evidence this is relevant. Substance abuse history. This is contained in defendant's exhibits, addressed in multiple reports of mental health, and the family can testify. History of maltreatment and neglect. No evidence this is relevant. Trauma history. Records related to childhood car accident. You guys ever heard of this? Did you guys hear of Bryan Kohberger getting into a childhood car accident? Cheryl T., it is so good to see you tonight. How are you? No, I haven't heard about this either, Shell. So, records related to childhood car accident contained in defendant's exhibits, addressed in multiple expert reports of mental health professionals, and family members can testify about it. I had never heard that either. I'm going to actually screen record this, or not screen record, but screenshot it. This is why you kind of have to just walk through these documents one by one, because you never know what's going to be in here. The next thing is educational history, and this is in his exhibits, addressed in the mental health reports, and family members. Look at this one, though. We're going to have teachers, I think, and other school people testifying here. I'm going to go off camera for a minute. Ugh, I got to adjust. Okay. Family members and other identified witnesses, including former teachers. MB, JC, CH, DM, AP, KR, and DW. We got 1, 2, 3, 4, 5, 6, 7 former teachers. Thank you, Cutesy Claus. Hey, tell Molly I said hi, by the way. Cutesy Claus. Any missing educational records have been available to the defendant. Oh, sorry, I didn't finish this. Former classmates, MD, AH, AHM, AM, CM, and EP can testify about this topic. So we have 1, 2, 3, 4, 5 ex-classmates. I wonder who they are. And I wonder if they're really, really excited to come to Idaho and testify in a quadruple murder case. My God. We did hear from some of his teachers in that one documentary, if you recall. Or maybe it wasn't a documentary. Maybe it was a news report. I don't know. It was a long time ago. Let's continue on here. So that's interesting stuff. Employment and training history. Defendant has limited employment history. Family members and other identified witnesses, including professor he worked for, JS, and former coworkers, can testify about this topic. But if we go back here to former classmates, I don't see Arts, Casey Arts, as a witness. Well, sometimes I get this mixed up with Stearns because he also had a head injury. And they were looking for his medical reports to go over, and they weren't able to get them. I guess so, Beans. This says multi-generational family history, genetic disorders, and vulnerabilities, as well as multi-generational patterns of behavior. Family members can testify, and it's all in his exhibits. Prior adult and juvenile correctional experience, not applicable. Religious, gender, sexual orientation, ethnic, racial, cultural, and community influences. Here we go. Family members and other identified witnesses, including fellow congregants, EMJR. Acquaintances, AF. Friends, BADF. And neighbors, ANA, what the heck? AUA, FA, and GN. At least some religious history contained in discovery. So now we've got church friends? Oh, maybe the visual snow? Jammers. Hit the like button, guys. Get us out in the freaking algorithm. All right. Socioeconomic, historical, and political factors. Family members, the same thing here. Witnesses, fellow congregants, EMJR, AF, BA, DF, and neighbors. So he's gonna, hey Linda, he's gonna subpoena neighbors to Idaho. Witnesses defendant wants available per ABA guidelines. The client's family, extending 3 generations back. And those familiar with the client. Yeah, these are all PA people. The state's response. All living family members are subject to the subpoena power. Many have spoken to the defendant's expert witnesses and are on the defendant witness list. CEAK. MeK, MaK, MEK, RK, and SK. Who are these people? Melissa Kohberger? Who are they? Who's RK and SK? Kohbergers, right? God almighty, the client's friends, teachers, classmates, coworkers, employers, and those who served in the military with the client. He didn't serve in the military. So then again, they list these defendants' witness list. Social service and treatment providers to the client and the client's family members, including doctors, nurses, other medical staff, social workers, etc. At least one psychologist who evaluated defendant as a child. Ooh. Remember way back when I found a lawsuit where Bryan Kohberger's mom sued a psychologist? Do you guys remember that? Who's KK? Because why would Bryan Kohberger have been evaluated as a child by a psychologist? But I saw a lawsuit and I cannot find it for the life of me now. But his mother sued a psychologist, and I think she was in California. It was weird. And then witnesses that are familiar with the client's prior juvenile and criminal justice and correctional experiences, not applicable. Family members can testify about defendant's behavior generally. Then we have former and current neighbors. And then they have defendant's witness list contains neighbors. 4 different neighbors. And the state says family members are best positioned to testify about this. Witnesses who can testify about the applicable alternative to a death sentence. Defendant has retained and disclosed an expert witness, J.A., to testify about this topic. And then witnesses who can testify about the adverse impact of the client's execution on the client's family and loved ones. And the state responds by saying family members are best positioned to testify about that. Woo! Okay, so we got through that one. That one's a pretty big one, though. That's got a lot of witnesses that we didn't know about, things we didn't know about here. Let's move on to the next one. That was that this one? Comes now, the state of Idaho supplements its motion on May 13th regarding the state's log spreadsheet. So that must be what we just read. This is confusing. There's a lot of things here, so bear with me. So this is Bryan coming forward with a motion to seal stipulation and order for admission of additional exhibits. Look at admission, ADD. I don't know why they don't spell check these. Glennis Randy. I'm not a lawyer. I don't know what you're talking about. Comes now Bryan Kohberger by and through his attorneys of record. Hereby moves the court for an order to seal the parties' stipulation for admission of additional exhibits as evidence at trial in its corresponding order. And they still have Jay Logsdon on here. I don't know why. I thought he was off the case. And here is another one. This is just 2 pages. Motion to seal defendant's second amended phase 2 mitigation witness list. So a lot of these are just motions to seal everything. Motion to seal defendant's offer of proof, RE alternative perpetrators. Comes now the state of Idaho. Moves the court for an order sealing the state's objection to defendant's offer of proof and attached exhibits. So they put exhibits in there of, and we're going to watch a little clip from the last hearing about those exhibits. Mm-hmm. Here's a motion to seal more exhibits. This is Bryan. Motion to seal stipulation and order. Oh, we looked at that one. Order granting leave to exceed page limit. Stephen Hippler signed this one. He said, hey, it's okay that he writes 40 pages. We're good. Hey, Lucia, what's happening? Order sealing defendant's motion and order for independent analysis of evidence. This is where we're going to get into our video. Check this out. The court having before it the motion to seal defendant's motion and order for independent analysis of evidence. So Stephen Hippler is letting the defendant examine independently some evidence Diana, you're here. Order sealing defendant's motion and order for independent analysis of evidence. So what do you think they're going to be analyzing? What evidence? Let's switch over here. I'm going to give some shout out to Anjanette Levy because this kind of plays on this order that we're talking about. Listen.
Something is going on behind the scenes in Bryan Kohberger's case, and it could impact his upcoming trial as Judge Hippler grants the accused killer's request to analyze evidence. I take a look at what it all means and why prosecutors are pushing back on his request to delay the trial. Bryan Kohberger's trial is scheduled to begin on their way, Quest big time. And let me tell you, looking at the court documents, something is going on behind the scenes. New motions have been filed and they're all sealed, but we know basically what they discuss. But there's more. Judge Hippler has granted Kohberger's request to have evidence analyzed by an independent expert. Unfortunately, I can't tell you what that evidence is because the motion requesting it is sealed. And
so what would they be analyzing, you think? I mean, it could be anything. There's so much evidence in this case, but what do you think specifically they could be looking at? So they get to bring in an expert analyst to analyze some evidence independently. Does that mean that the prosecution can't even be there? I wonder what the hell it is.
so is the order. But he granted the defense motion to have the evidence analyzed after prosecutors filed a response. We don't know if the prosecution objected to the request because it's also sealed, but we do know that prosecutors have told Judge Hippler they are opposed to delaying the trial.
So what the heck? The sheath maybe, or the phone pings? Maybe the blood? They're sealing everything. So what's wild to me is Hippler started unsealing shit. Now the shit's getting sealed again. Even the responses are sealed.
Now, Bryan Kohberger's lawyers have said he maintains his innocence in the murders of Maddie Mogen, Kaylee Gonsalves, Ethan Chapin, and Xana Kernodle. All four were stabbed to death in the home on King Road in Moscow, Idaho in November 2022. Kohberger is due back in court next week on June 18th when his attorneys will argue behind closed doors that they should be allowed to tell the jury about other suspects who could have carried out these murders. Prosecutors are objecting to that, too. They say there's only one suspect, and it's Bryan Kohberger. But Kohberger's lawyers have said there are other suspects who were not investigated by law enforcement.
See, this kind of freaks me out a little bit. Because now they said in this last hearing, and we're going to hear that in a minute, we're going to hear that they came across a tip and they are saying there was two people, y'all. When I heard this clip again, now I watched the hearing, but I didn't catch this until I watched this show, Crime Fix. Hey, Jody, and hey, Sherry, baby. Come on in, guys.
Here was Ann Taylor at a hearing earlier this year.
We're not completed with that. I think I've read most of the police reports in this case, but I haven't read the thousands and thousands and thousands of tips that came in on this case. Don't think they're all not relevant, though. Recently, we came across a tip just in trying to work through some of these issues. We came across a tip that would appear to be an alternate suspect, and we're trying to work through that as rapidly as we can. It was quite a surprise to come up with that. There's got to be more in there that I need to know.
And Ann Taylor plans to argue at trial that two people carried out these murders, and neither one of them was Bryan Kohberger.
Your Honor, we have produced an expert that believes that it's likely that there were two people, two weapons. That doesn't
testimony about the degree of intoxication goes to the what I'm assuming was, given that degree of intoxication, the ability to fight back. In rebuttal to your experts, as I understand it.
I think that's what the state says. I don't think that's proper rebuttal.
So the state is going to say back, well, the victims were highly intoxicated. They couldn't fight back. We don't think there was more than one person. But she's saying there's a tip. Hey, Micro, thank you for being a fan, super fan for 15 months. But Judge H is great, but goddamn dude needs a water bottle at all times with his sticky mouth. I agree. It's very rare for a defense to be allowed a third-party culprit defense. Well, I mean, hey, full deck, they're putting exhibits to back it up, right?
Well, because we didn't talk about intoxication, because the state's medical examiner talks about defensive wounds anyway. So this would seem to be contradictory with other testimony that they intend to put on.
Okay, so I had a really weird tinfoil hat moment. Now, bear with me. Snazzy. I had a tinfoil hat moment. What if Bryan Kohberger called in false tips while he was still loose? What do you think of that? We know that he was probably playing games. He was harassing that photographer and God knows doing what else. What if he called in fake tips? What if they don't even realize it? That they're fake? Like, my mind went in this place where Bryan Kohberger is a total mind fucker. And I'm wondering if he didn't, yes, like the Papa Rogers and the inside looking and outside looking. And what if Ann Taylor doesn't even know that the freaking tip is him? Oh my God. Like, listen to that part again. Here, listen.
An expert that believes that it's likely that there were two people, two weapons. That doesn't
testimony about the
Wait, hold on. It was this part right here.
not completed with that. I think I've read most of the police reports in this case, but I haven't read the thousands and thousands and thousands of tips that came in on this case. Don't think they're all not relevant, though. Recently, we came across a tip just in trying to work through some of these issues. We came across a tip that would appear to be an alternate suspect, and we're trying to work through that as rapidly as we can. It was quite a surprise to come up with that. There's got to be more in there that I need to know.
And Ann Taylor plans to argue at trial.
Well, that's a good question, LA. Hey, Candy Wrapper. That's a good question, LA, because they have. So they filed that they thought there was an, alternate suspect, but they didn't put any evidence with it. So the judge was like, no, you have to include some evidence. And now they have, and it's under seal. Oh my God, Lana, I can't.
That two people carried out these murders, and neither one of them was Bryan Kohberger.
Your Honor, we have produced an expert that believes that it's likely that there were two people, two weapons. That doesn't
testimony about the degree of intoxication goes to the what I'm assuming was, given that degree of intoxication, the ability to fight back. In rebuttal to your experts, as I understand it.
I think that's what the state says. I don't think that's proper rebuttal. Well, because we didn't talk about intoxication, because the state's medical examiner talks about defensive wounds anyway. So this would seem to be contradictory with other testimony that they intend to put on.
Okay, so basically what she's saying, it's kind of contradictory from the state. Now hear me out. Hear me out. The state is saying there's only one perpetrator, and the reason we think that is because of the defensive wounds from the victims. Right? But then on the other hand, they want you to think that the victims were very intoxicated, therefore more subdued. So how can you have it both ways, guys? How can you have it that the victims were overly intoxicated to where one person could commit this, but then you're saying there's defensive wounds? I'm confused on that.
We are not contesting the intoxication level of any of the deceased.
Now back to these new court documents and what has piqued my interest. A motion for an emergency order was filed last Friday, and it was sealed, along with the state's response to the defense motion for independent analysis of evidence. Then on Monday, Judge Hippler granted the defense's motion. That same day, Hippler sealed an order, staying an order. So that is sealed. So this indicates Hippler issued a stay on one of his own orders and then sealed it. Now, why we don't know is
So what does that mean?
defense's motion. That same day, Hippler sealed an order, staying an order. So that is sealed.
He issued an order staying his own order. So order sealing state's objection to defendant's offer of proof. Let's look at this really quick. Order sealing the state's objection to defendant's offer of proof, RE alternate perpetrators, and defendant's evidence in support of offer of proof, alternative perpetrator. So they did offer evidence. Based upon the motion to seal state's objection to defendant's offer of proof, the court does hereby confirm an order that it is exempt from disclosure and sealed. So the state is objecting it, whatever they put in. And then we have that one, order sealing the independent analysis. And then we have this from Judge Hippler. Order sealing stipulation and order for admission of additional exhibits. It is hereby ordered the party's stipulation for admission of additional exhibits as evidence at trial is filed under seal. So we got that, and then motion to seal defendant's motion and order for independent analysis of evidence. Comes now Bryan Kohberger, moving the court to seal the defendant's motion and order for independent analysis. Sealed. And then we have this one. Motion to seal defendant's notice of filing amended exhibit chart. And then we have the order sealing it. So Hippler is sealing everything. Let's go back to our video now.
So this indicates Hippler issued a stay on one of his own orders and then sealed it. Now, why we don't know. Is one side appealing something? We don't know that either. Judge Hippler had been opposed to sealing documents not too long ago, but now many things in the case are being sealed again.
Okay, so why would that be? Is that because of the Dateline episode, you think? He's going to seal shit because he's pissed? I don't know.
We've all heard that wrinkle creams are gotten on and was on the defense request to delay the trial. The prosecutor's right. It is time to try this case. Defendant was arrested in late December of 2022 and was indicted in May of 2023. He successfully moved to transfer venue to Ada County. And
maybe they are 2-year-olds are running the world. That's what I'm thinking. I feel like maybe Bryan called in a false tip on Kopeka. We went through this earlier, but we'll do a recap with And Jeanette Levy.
In October 2024, this court entered its scheduling order setting deadlines for pretrial motions and expert disclosures. Defendant complied with those deadlines without moving for a continuance, including by disclosing 6 expert reports for the penalty phase, disclosing over 2,100 pages of purported mitigation materials, listing 55 penalty phase witnesses and identifying 132 exhibits he may introduce during the penalty phase of trial.
It's a lot.
Now, in the state's opinion, the defense has had plenty of time to prepare for trial, but Ann Taylor has said previously she still needs more time, and she's quoted case law about death penalty cases that say death is different.
Do you know that Ann Taylor, I believe, has at least one other death penalty case going on at the same time? He did. He said, who else was arrested, or was anybody else arrested? But I think that was all part of a game, if you will.
She's quoted case law about death penalty cases that say death is different. Taylor claims there is still discovery that she wants and needs, and she says she needs more time to prepare for a possible penalty phase in the trial. Now, prosecutors argue that Kohberger and his team, that they've had plenty of time and they have plenty of resources. Defendant has 3 attorneys, including a lead attorney who has represented him from day one, 2 investigators, and the assistance of at least 1 additional public defense attorney.
So they're saying he's had plenty of resources. He's got a big team. She's been asked if she needed more help. She said no. I think it was last August. The judge asked her if she needed more help, and she said no.
He also has engaged an outside mitigation specialist to assist in obtaining materials for use during the penalty phase. This record reflects that this defense team has been working hard for defendant and, as explained below, has met the professional standards for the defense of a death penalty case. Now, prosecutors are also pushing back on Taylor's claim the defense needs more time to complete a social history investigation. And the elephant in the room with all of this is that Dateline special that aired in May. That special aired evidence that hadn't been revealed before, and it included video from a house next door to 1122 King Road that shows suspect vehicle 1. It also included information about Bryan Kohberger's Google searches from his phone and selfies of Kohberger wearing a black hoodie and claims that he was searching serial killer Ted Bundy on Google. But
do you know that I had a comment on one of my Kohberger videos today about the hoodie, these selfies right here of him in the hoodie, the black hoodie or whatever. They said they were photoshopped. Hey, Regina.
Bundy went to college in Washington State and killed women across the country, including sorority sisters. Judge Hippler was livid about the special, and so was the defense. Hippler made it clear that he believed the information was leaked by law enforcement or a current or former member of the prosecution team.
Yep, I
Kohberger's
swear they
lawyers
did.
say that special as part of their request for a delay, but prosecutors say it's not necessary. They write, there is no doubt that the publicity surrounding this case, including but not limited to a recent Dateline TV show containing non-public evidence, poses challenges for the court and both parties. The state reaffirms its commitment to comply with the court's non-dissemination order to do everything in its power
So
to
this is
prevent
about
leaks,
Dateline,
public information.
the jury.
This morning,
We read that, but I want you guys to hear this. I want you guys to hear this clip.
That information to Dateline.
in the closed session this morning, I indicated to you I'm going to be entering an order requiring the retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like
Hi, Newfie.
that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity.
His voice.
So I will be looking for that from you. And that one just deals with the state. I will get you one that deals with your side to preserve records. All right.
So I want to bring in Philip Dubé. He worked as court-appointed counsel in Los Angeles County for years. He could have represented somebody like Bryan Kohberger, somebody in his
Okay, I want to play this because I really enjoy his commentary. He cracks me up, but I really like this guy. I don't know if you guys do, but I want to hear what he has to say about the ceiling and all this.
shoes. First off, Philip, you believe that the defense should be given a little bit of a continuance, but now the prosecution's saying, no. The time to try this case is now. Let's get the train. The train is on the tracks. Keep it moving. Your response to that?
We don't win trials by ambush. If counsel for the defense is saying that they are not ready and they have good cause for needing to put it over, then so be it. You don't get a leg up in winning a prosecution merely because your opponent is not prepared. That's not how we try cases, particularly in a capital case. Again, we're not talking about somebody passing a bad check, joyriding a car, or a simple assault and battery. We're talking about a quadruple homicide.
Okay, I disagree. I think they've had plenty of time. Again, she was asked in August if she had needed more help. She said no. Plus, she took on another DP case.
They're seeking the death penalty. And if counsel is saying, I need more time for the following reasons, and they have good cause, the court is obliged under not just Idaho law, but under United States Supreme Court precedent to grant that request. There was case law that came down from the high court, I think it was in the 60s, in the context of a criminal contempt proceeding where the court did not want to grant a continuance. And the standard was the denial just arbitrary? If it's arbitrary, well, then that's grounds to reverse a conviction and it could go back to the trial court. And I seriously doubt the judge assigned to the case is going to want to retry a behemoth 4-count homicide. Idaho law is in accord with U.S. Supreme Court precedent, but also adds that you have to show prejudice from the denial of your continuance. And here, if Ms. Taylor needs time to work up a defense, to get records, to provide additional materials for an expert so that they can prepare or put on or even rule out a defense, that's why we have continuances. We don't do it to give either side a leg up and just sort of win by ambush. It's simply not the law.
I was a little surprised to see the prosecution say the defense has had plenty of time to work up their case. It's interesting to me that they would say that. I mean, I guess they are entitled to say whatever they feel or whatever they think. They say, they've produced all of this stuff. They've given us their mitigation experts. They've produced all of this material to us. They're ready to go. They're fine. But if the defense feels truly, and they are representing somebody, and this is a capital case, that they do maybe need a little more time, and they haven't specified an amount of time, maybe 30 or give them 30 or 60 more days. I don't know. You said 90 the last time we talked about this, and to keep her on a short leash, Ann Taylor. I mean, it kind of is like, it is a death penalty case. This is a big case. So if we're looking at it from, the standpoint of fairness, like, then maybe what is the big deal if you push it to like January? What would be the big deal? So were you a little surprised to see the prosecution be so bold and say, and I understand for the victims' families, this is horrific. Like, they want this over. But for them to just say, oh, they're ready. They've had plenty of time.
Well, as far as I'm concerned, prosecutors have no standing to say when their opponent is ready, just like we have no standing on the defense side to say when prosecutors are ready. You need to be ready by tomorrow. Otherwise, we're going to ask that this case be dismissed. It's like, halt, not so fast. You don't get to dictate the rules. You don't get to dictate when either side is ready, and you don't get to dictate when either side needs more time. And I think we talked about in a prior episode how it'd be one thing if counsel is saying, look, my family and I have a prepaid vacation, or my dear sorority sister is having a destination wedding in Vienna, and I promised that I would be there. We're going on a cruise that was planned 2 years ago for a family reunion. No, we're talking about ongoing preparatory work in a 4-count capital murder prosecution. And she laid out with some pretty specific detail why she needs more time without getting into her actual work product and certainly without getting into attorney-client privilege type conversations. So now the burden shifts really to the court. And the court, or the ball's in the court's park to make a ruling and make a decision. And it should not be arbitrary, and it should not prejudice the defense in any way. And if we're honest, how would the prosecution be harmed? They're going to get all the evidence. They'll get all the time that they need to look at it. And meanwhile, you kind of get past the summertime when people might have pre-planned vacations, kids are out of school, you want to spend time with your kids, and you certainly want it to run past the holidays so you're all not under the mistletoe together during a capital murder trial.
What? Under the mistletoe? Is this guy AI? Come on.
Might have pre-planned vacations, kids are out of school, you want to spend time with your kids, and you certainly want it to run past the holidays so you're all not under the mistletoe together during a capital murder trial, trying to get home to put up a tree, spin the dreidel for Hanukkah, light the Shabbos and the Hanukkah candles, all that kind of stuff. You don't want any type of capital murder trial to get in the way of the high holy days. So what do? You put it over, give everybody ample time to work it up so that it is a fair prosecution.
Now let's talk about the Dateline special, because that's kind of thrown a big bomb into the middle of all of this. The state is basically saying to the judge, now they're saying the Dateline special has kind of mucked everything up as well and created all this prejudicial pretrial publicity. The state says, we are committed to upholding this non-dissemination order and helping the court in figuring out who did this, who leaked this stuff, whether it's one person or more than one person. But they're saying, if we delay this, that still just gives more time for more leaks. There's going to be a book coming out right before jury selection, Philip. So there's going to be publicity.
Watch his
There's
face.
going to be a book coming out right before jury selection, Philip. So there's going to be publicity surrounding that. They're concerned about that. What do you say to the prosecution's argument about the Dateline stuff when basically Judge Hippler's like, I think it came from your side?
The reason why the prosecution is concerned, and I'm not saying that they had a hand in this, but if those leaks came from the DA's office or from law enforcement, what it does is it puts forth or gives rise to the remedies that the defense has to either get the case dismissed, maybe to get counts kicked, maybe to get the death penalty off the table. And certainly it would be grounds for a continuance to look into it. And I think what counsel is trying to do is cut the time so short that they could not be affected by a judicially crafted remedy as a sanction for any type of law enforcement or prosecutorial leaks. And I understand that. And I'm not saying that's what's happening, but that's certainly sort of the message. And if we're all honest, it does look pretty suspicious. What is the harm in giving the defense another 90 days just to get up to speed? It takes you past the summertime, hopefully get you past the holidays so everybody is on equal footing to get to the truth right after the New Year holiday.
Philip, let's now get to the sealed stuff, the stuff that's kind of secret right now.
Wait, let's talk about this a little bit further. The delay, okay? So I said when we first started, the trial is set to begin August 11th. It's slated through November 6th. We could possibly have a verdict on the anniversary of the murders with that timing. Now, like he said, if they give 90 days, that doesn't start until right around the anniversary, which would take us into 2026. So, yeah, the timing is pretty wild that they did it that way. By design?
Defense motion for independent testing of evidence. We don't know what that evidence is, but the judge granted it. And it could be something to do with the sheath. We don't know that. But this, I would think, any testing of the sheath or analysis of the sheath should have been done a long time ago. So it could be physical evidence. I'm wondering, does it have anything to do with the unidentified male DNA found inside the house and outside the house?
Could it be that? Could it be the blood on the railing?
I just don't know. So could that possibly delay the trial if there's independent analysis of evidence going on?
Well, a couple of points. I'm really glad that this judge sealed that.
Okay, hold on. Let's put Philip on hold for a second. Hold on.
We just don't know. So could that possibly delay the trial if there's independent analysis of evidence going on?
So wouldn't it be wild? Oh, man. Wouldn't it be wild if they were able to test the blood on the rail because the prosecution, the investigators didn't test it? And let's say the blood on the rail matches the second perpetrator in the tip. Does that make sense? I agree, crafting and true crime. I agree with you. But he's saying they should give 90 days because it's a capital case, not risking the conviction getting overturned and things like that. That would be freaking wild, Regina. Crazy wild. I thought they didn't test it. Or did they? And it was inconclusive. Is that what it was? Inconclusive DNA? But I could have sworn that Brett Payne said they didn't test the other DNA. I'm going to look that up.
Well, a couple of points. I'm really glad that this judge sealed that. The rationale behind the rules of sealing court and public documents in the state of Idaho, despite their sunshine laws, is to ensure a fair trial. Certainly you don't want more leaks. You don't want a lot of speculation in the jury or future jury pools out there as to what, if anything, they have on this man. So from that standpoint, I'm glad right now that it is not made public. Now, having said that, we don't really know what it is that they're seeking to have tested, but common sense dictates that it has something to do with that knife sheath. For all we know, it is possible that new technology has come out in the DNA world since the arrest and since the last testing of the evidence against him that could be a little more sophisticated and shed light on perhaps an alternative perpetrator that they could lay their hands on for purposes of a defense. And if that's the case, I think the judge is obliged to give them more time because the standard is good cause. Do they have good cause? Are they really making diligent efforts to test evidence that's being held against their client? And if that's the case, I think the judge is obliged to give them the testing time that they need, the time to get a report generated, and certainly time to get it to the prosecution so that they can rebut it. What I have done throughout my career, Anjanette, and I'm sure a lot of defense attorneys have done this, is that when they ask for more time, they will agree and stipulate to a reasonable continuance of the proceedings for the prosecution so that they have ample time to review and look at and test and retest and analyze the additional defense discovery. That's typically how you cure it. So you show that it's not really antagonistic, but you're kind of working synergistically to get to the truth.
And now we've got an order sealing a stayed order. And there was an emergency order, a motion for an emergency order. So there's a lot going on that's sealed, going on behind the scenes, Philip. So is the judge just sealing all of this? He was all for everything being unsealed, or at least things being redacted and not sealed. Is he doing this because it is so close to trial and because of the Dateline leak, and he's just like, I just can't let everything get more messed up than it already is?
Well, the clue that I look for in terms of interpreting his reasoning is the rule itself about sealing court documents. And there's three main buckets of records that people tend to want to have sealed. Number one, anything personal and confidential about a litigant or a witness or a victim. Maybe psychiatric histories, who knows, maybe a loathsome disease of some sort, maybe a criminal past. You don't want certain things to be made public that are otherwise non-public. There could be financial type records in the file. And I'm not saying that that's the case. The world doesn't have the right to know how much I have in my checking account, how much I might have in a mutual fund portfolio. That is confidential. But third, the most important of all the categories for considering whether or not to seal is whether or not it can in any way compromise getting a fair trial. And because of the leaks that have come out through this Dateline episode, the court wants to be extra circumspect in making sure that nothing is leaked to the public that could in any way, shape, or form compromise Bryan Kohberger's right to a fair and speedy resolution of his case. So he's just being careful, and he's invoking that rule, and I actually respect it. Now, I mentioned to know what's in there, and I know you are, and so is the rest of the true crime world, but our interest in wanting to know has to be balanced against that right to a fair trial, and I think that right to a fair trial is going to trump our nosiness, frankly.
Of course. Well, we will see what happens next week, especially with the continuance. Philip Dubé, thank you so much.
Have a great one.
And that's it for this episode.
Okay. I did find a little bit about this. Let's see. Right here. Let me pull it up. We will read through this. Let's go over here. All right. This is the order on defendant's motion to suppress genetic information. Let's see. This does say something about pain. So hold on. Let me scroll through here and this is about the Jed match, but it's in here. God, this is long. I wish I could find something that was break it down. But remember Brett Payne? He was in that hearing and he testified. Hold on. Let me keep looking here. He said that they didn't look further. They know that it's, I don't know, how do they know it's male without identifying who it is? Here we go. I got an article here. Hopefully this will help. Oh, by blood type. Okay, so let's read this. Bryan Kohberger was not on the radar of police in Moscow when he was stopped twice for traffic violations on a freeway in Indiana. I don't know if I even believe that. I'm not sure I believe that those cops didn't know who he was. I don't know. Okay, so it says a newly released transcript of a court hearing in preparation for his trial. That was right. It was the closed hearing. They released the transcript. In the hearing, a Moscow police detective, which was Brett Payne, revealed for the first time he heard Kohberger's name was on December 19th of 2022. That was just over a month after the murders and 4 days after the traffic stops in Indiana. That timeline bothers me. In the court hearing, which was closed to media and the public, Detective Corporal Brett Payne said he first heard Kohberger's name when the FBI called regarding the investigative genetic genealogy. Investigators were trying to determine who left DNA on the knife sheath at the crime scene. Detective Payne said all the FBI conveyed to Moscow police was that it was Kohberger. Once we received his name, we set about basically an independent verification of whether or not he was involved in this crime, Payne told the court. In a meeting the next day, Payne said investigators met with the FBI over Teams and further discussed the family tree and how that played into Kohberger's ID. They essentially worked their way through the family tree and arrived at a conclusion that Kohberger was a person we should look into as a tip. This is Brent Payne. He was also questioned about other evidence found at the scene, including a sample they call unknown male B. That came from a blood spot on the handrail between the first and second floors of the home. Payne said because they already had a possible match on the DNA for the knife sheath, they held off on testing unknown male B until a later time. The defense also questioned Payne about unknown male D, which was blood found on some gloves outside the home. It's not entirely clear if those samples were submitted to the lab. So we don't know. I mean, are you guys satisfied with that? They had a possible match on the DNA of the knife sheath, so they held off for a later time? What does that mean? This is a capital case. Why wouldn't you check it all? Why wouldn't you check? So there's an unknown male B and an unknown male D. What about A and C? I mean, why is it just B and D? Where's A and C? That's what I want to know. It doesn't make sense to me. I don't like that part of it. That doesn't make sense. So I think at this point, we went through all these documents, right? So now I want to go deeper in the witnesses because we do have some information, thanks to JLR, of some of the witnesses that are going to be testifying for the defense, like the teachers and such. He did identify a few of them. So let's take a look here. So this would be MB, DeSales professor Michelle Bolger. She's going to be subpoenaed to testify. Remember her? Let's look up Michelle Bolger. Michelle Bolger. Right here. She said he was a brilliant student. This is her. She's an associate professor at DeSales. She said, I'm shocked as shit at what he's been accused of. I don't believe it, but I get it. This news is upsetting. I haven't slept at all since hearing about Bryan. She told the news that she taught him in an online class and helped him with his master's thesis at DeSales. I never saw him in person. I couldn't tell you how tall he was or how much he weighed. My only interaction with him was via Zoom and email. I don't know anything about him, whether he was married or had a girlfriend, etc. He seemed normal to me, but then again, I only was teaching him online. I don't know anything personal about him. I believed he worked full-time like most of our graduate students do, she added. She advised Kohberger with his thesis, which involved questioning people about their thoughts and feelings during the commission of a crime. I was one of the professors who helped Bryan with his proposal on his graduate thesis, his capstone project. He did a routine questionnaire for his thesis. It looks weird. I understand from the public view, but in criminology, it's normal. Then she says it's a criminology theory called script theory. It's a normal theory on how and why criminals commit their crime, etc. So there we go. That's one of the witnesses is Michelle Bolger. Because there was like 7 teachers. Okay, let's see who else. Ralph Vecchio will be testifying at the Bryan Kohberger trial. I don't think he's testifying against him. I think this is a defense witness, but he is the president of Colonial Auto Sales. He sold Kohberger the white Elantra. Well. Let's look at Colonial Auto Sales, PA. Here it is. There you go. This is where Bryan bought his Elantra. Hello, Joe. Hello, Joe. Hey, Pam. Okay, so that's RV, Ralph Vecchio. Then we have Bryan Kohberger's former Pleasant Valley school teacher, Ann Parnham, which is AP, has been called to testify against him at trial. So this is Ann Parham. Let's see. Ann Parham, Pleasant Valley Schools. Yep, here she is. Teacher at Pleasant Valley in Effort, PA. So there's a few of the witnesses. Oh, Jesse Harris is another one. This is the gym guy. This is the last one we know of. So Jesse Harris would be JH. And Kohberger boxed it at his gym. Let's see what this is. JLR. Hold on. I think he went there. He did.
Investigates. I am covering the Moscow, Idaho Bryan Kohberger case. I am on Route 209 in Effort, Pennsylvania. And right across the street is a Wawa. Bryan Kohberger.
Oh, Wawa.
Used to box. Boom, boom, boom. At the Jesse Harris boxing. Used to box. Boom, boom, boom. At the Jesse Harris. Used to box. Boom, boom, boom. At the Jesse Harris boxing.
Welcome in, BZ
right here at the
Mama.
Wawa. This is right down the street from the Pleasant Valley School District. Yeah, he used to box. He put it on his resume when he was applying to work for a security guard at the Pleasant Valley School District. Let's check it out. On Bryan Kohberger's school application to work for the Pleasant Valley School District, he wrote...
Ooh, there it is. I boxed after school every day at the Jesse Harris boxing gym on 209 near Big Cheese Pizza.
I boxed after school every day at the Jesse Harris boxing gym on 209 near Big Cheese Pizza when it was still open. I also attended a year of the law enforcement program and a year of HVAC at MCTI. So Jesse Harris boxing gym on 209 near Big Cheese Pizza. So Route 209, right by the Big Cheese Pizza. If you Google map it, it's this location right here. It's
where the Wawa is.
No more boxing gym. It is a Wawa. It is a Wawa. It is a Wawa. It is a Wawa. So Kohberger used to box here. And I think it's important to know, considering 4 college students got brutally stabbed in the middle of the night. Guy with bushy eyebrows. Got to be physically fit, right? We've heard that Kohberger was a runner. He used to run, jog, ran 5-minute miles. Then hearing that he also boxed. Unless he lied on his resume, and that could be a possibility too. But it wouldn't surprise me if Bryan Kohberger was a boxer.
Well, now we know. Jesse Harris is going to testify in the trial. So we got Jesse Harris. We've got Ann Parnham. We'll be seeing these guys up on the stand probably. Ralph Vecchio. And Michelle Bulger. Now, we're going to go a little bit further. I've got more for you guys. Hold on. We're going to get into... Ann Jeanette has her own YouTube as well, and she got the documents from PA of these people who are going to be witnesses. Let's hang on. Let me pull this up. Okay. So she
and
hold on, let's find these documents here. Okay, right here. Listen.
so here we go. Is this not going to let me and
okay, so this says thank you, Betsy. But wait, there's more. Thank you for your super chat. I can't zoom this in, unfortunately. It won't let me. Hold on. Anyways, so it says here, order scheduling a hearing on petition for summons for Maggie Sanders. And this is in Pennsylvania, in the Common Court, in the Court of Common Pleas of Monroe, Pennsylvania. Here, let's just listen.
she's being told, hey, Maggie, get down to the courthouse on June 30th. And so basically, these are out-of-state witnesses. So the defense for Bryan Kohberger.
So these people don't want to go, okay, is basically what she's going to tell you. So let's read this. Maggie Sanders is a material and necessary witness in a criminal proceeding pending before District Court for the 4th Judicial District, State of Idaho. Compelling the attendance of testimony of Maggie Sanders will not cause undue hardship for her. The laws of the state of Idaho, where the prosecution is pending, and any other state through which Maggie Sanders may be required to pass by ordinary course of travel, provide protection to her from arrest and from the service of civil or criminal process while traveling to, attending, or returning from the proceeding. A summons shall issue with a copy of the certificate issued by Honorable Stephen Hippler, attached, directing Maggie Sanders to attend and testify in the criminal proceeding pending in the state of Idaho. And then it gives the dates. So, who's Maggie Sanders? Who is she? Look, here it actually is. I found it. She has to be there June 30th. For a trial that begins August 11th and ends November 7th. They want her for 2 days. Oh, look at Pocono Record. Look at right here. Oh, you have to pay? Oh, shit. I want to read it. Look at it. It says, these hearings will determine whether or not Ann Parham, Brandon Andriola, Jesse Harris, Maggie Sanders, and Ralph Vecchio will have to testify. So we know that Jesse Harris is the boxer. We know Ralph Vecchio is the car guy. Ann Parham is the teacher. Who's Brandon Andriola? I think he's a friend of Bryan Kohberger. Let's look him up. He's a real estate agent. He was in the Army? Oh, snap. Real estate agent, investor, U.S. Army. He probably went to school with freaking Kohberger. Oh, his shit is private, too. Wow. Here he is. Brandon Andriola. He's a real estate agent now. In Arizona. Right here, maybe we can read this article on Yahoo. Yep. 5 ties. Okay, here we go. 5 people with ties to Monroe County are being subpoenaed by the defense in the trial of Bryan Kohberger. According to court documents provided by the Pennsylvania court system, 5 people, each described as someone who, quote, lives, works, or does business in Monroe County, has been ordered to attend a hearing on June 30th at Monroe County Courthouse. These hearings will determine whether or not Ann Parham, which is a teacher, Brandon Andriola, which is someone he was friends with, Jesse Harris, the boxer, Maggie Sanders, I don't know who she is, and Ralph Vecchio will have to testify in the criminal proceeding happening across the country. Kohberger, 30. He's 30 now. Wow. Wow. Thank you, Full Deck, for your $10 super sticker. We need to find out who Maggie is. Maybe she's a teacher, too. Maggie Sanders. Let's see. Pennsylvania. Let's see what it says on Reddit. Maybe they figured out who she is. Jesse Harris owned. Okay, we know that. Okay, we know all about that, but who is Maggie? I don't know who she is. What? Maggie Sanders. Somebody died in Pennsylvania with that name in December. There's a lot of Maggie Sanders. I don't know who it is. Can't find her. Let's see if the Post knows who she is. All right. Jesse, we know he is Ann. Ralph. Wait, now this one says Ralph Vecchio worked at the auto shop he frequented. Huh. Sanders and Andrea's relationships to Kohberger were unknown, so they don't know. I bet you she went to school with him or something. I know, it is a common name. Interesting, though. Okay, let's go back. Where the hell were we? Here. Okay.
Went to Judge Hippler, defense, they're being told you have to come down.
Her own show is a lot different than her scripted law and crime show, just FYI.
Seal.
Like, really?
They're no longer under seal in Pennsylvania. Idaho, the defense exhibits are no longer under seal in Pennsylvania. The Idaho exhibits are no longer under seal. So this was an ex parte sealed certificate of an Idaho district judge. Let's start over here. So the 4th District Court in Ada County is constitutionally and statutorily a court of record in the state of Idaho. There is a criminal proceeding pending before this court at case number CR blah, 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 Kohberger's case. The defendant in this case is charged with 4 counts of murder in the first degree and 1 count of burglary under Idaho law that is punishable by death. I'm the judge assigned. This is Judge Hippler. And the trial is scheduled to begin on August 11th and run through November 7th. So Maggie Sanders lives in the Commonwealth of Pennsylvania, and she's a material witness for the defendant. For the reasons stated in the affidavit of Alyssa Masseth, the presence of Maggie Sanders is required at the Ada County Courthouse in Boise, Idaho.
So Alyssa Mathis or whatever, the other attorney, filled this out.
Under the laws of the state of Idaho, if Maggie Sanders comes into this state in obedience of a summons requiring her presence at this trial, she will not be subject to arrest or service of any process relating to matters that arose before she entered the state under the summonses. This certificate is made for express purpose of being presented to a judge of a court of record in the state of Pennsylvania. And
all right, let's get to the next
her address.
one.
Sorry, guys. You are hereby commanded.
Oh, I guess now we know where she lives. So let's look her up. Maggie Sanders, Saylorsburg. Let's see. She's 55. Is this her? Why did this come up? Thank you, 22. Thank you for 22 months. Beans. Grateful for you. Love the content and the interaction. Thank you so much. Yeah, does that explain Kaylee getting punched? Margaret Sanders. Oh, so it's Margaret. That's why we can't find her. But she's a 55-year-old woman. Who would she be? Let's see if it says what she... Maybe she's a teacher? It doesn't say... I think it might be a teacher or something because 55 years old. I don't know. All right, let's see who else she's got here.
That laying aside all excuses, you appear in the district court of Idaho. Let's skip ahead. I don't want to show her address. So basically they're saying you're going to get fined like $100 if you don't show up. And so it sounds like Maggie doesn't really want to go. Maggie doesn't want to go.
None of them want to go.
And it sounds like Brandon Andriola, he doesn't want to go either. So Brandon is somebody who I would say is around Bryan Kohberger's age, and he's a real estate agent. I looked him up. So he's probably somebody who's known Bryan Kohberger for several years.
Mm-hmm.
I'm guessing that these people are more than likely people who are lay witnesses in the penalty phase. That's my opinion. There's been discussion.
Hey, Kay Miller, I read on Reddit, take it for what it is, she may have been linked to him as the psychologist at the high school he went to. Oh.
About, Ann Taylor has also mentioned in some of these hearings that it's taken a long time for them to really break through and get people in this case to talk to them and people to cooperate with them. So a lot of these people are probably like, I am not going to Idaho and getting up on that stand and testifying for Bryan Kohberger when he's viewed as public enemy number one by so many people. Like they don't want to do this. So they're like, we're going to have to like force you to do this, to come in. And if we get to a penalty phase, tell that nice story you told us about him. And we're going to ask you about how you don't want to be here when you're on the stand. You don't want.
So in other words, they said nice things about Bryan. So they want them to come back and say those nice things again. Because remember, Ann Taylor said they have over 100 hours of interviews of people that knew him in Washington, and none of them were good.
Want to be here because look at this. Like, who would want to do that? So Brandon is a realtor. Let's go to the next one. Susie, these did not just drop today. I got these on Thursday afternoon, really late. They came into my email. The court in Pennsylvania is pretty, so setting the fire on Passover at the governor's mansion. Cameras in the courtroom stinks. So here's our next person, Ralph Vecchio. I need to look a little more into Ralph Vecchio.
Okay, well, we looked into Ralph Vecchio, and he either sold the car or it was where Bryan got his car fixed. Do you think, I'm going to do a poll. Do you think BK is the sole perp? Not sure. Okay, vote in the poll.
But Ralph Vecchio is someone else who's being asked to come in. There's been discussion by Ann Taylor, or maybe it was Alyssa Masseth, actually, because I think Alyssa Masseth is the one who's doing all the mitigation stuff. She talked about how he volunteered at the Special Olympics. There was also something about him helping save somebody's life once and how he didn't understand that that could be mitigating evidence. So maybe these people have something to do with that. No, he was not the boxing coach. The other guy is the boxing coach, I'm pretty sure.
Jesse.
That's Harris, I think. Jesse Harris. So the other two people, one is Jesse Harris. I believe he's and if I misspeak on this, guys, I apologize. Jesse Harris.
Does she have a statue of the Pope? Is that the Pope? Like a bobblehead?
Who owned the boxing place where he trained. And then Ann Parham, she was a teacher. So she was somebody who taught him when he was younger. Oh, interesting, Hella. Hella, which one was that? Which one was the salesman? So basically these people are probably people
so Ralph is the salesman. Pretty much. So yeah, I mean, that's pretty much... We're up to speed, I think, on everything that is new. We've went over all the docs. We've gone over the witnesses that are being called into court on June 30th. And then we also have a hearing coming up on the 18th. And you can see that here. Now... If you see that's at 12:30, it says motion to continue, not sealed. But then they're going to also hear the motion on the alternate perpetrators. That part is sealed. So we'll be able to watch part of the June 18th hearing. I don't know what's going to be done first. Hopefully the public part, and then they'll shut us out for the sealed hearing. So I do have an event up. If you guys want to hit the notification, we will be live for this hearing for whatever we can show. All parties and counsel are present, so everybody will be there. Thank you, Locked and Loaded, for your super sticker. I appreciate that. Hey, Mike. Yeah, I'm just getting ready to wrap it up. We've gone over everything. Thank you guys for joining. Let's see where we stand in the poll. Get your votes in. Wow, 73% of you guys think yes, he's the sole perp. 12% say not, no. Ugh. And 17 say I'm not sure. I must say, I'm interested in the alternate perpetrator evidence. And right now, I'm falling in the not sure category. Don't hurt me. Don't hurt me. It's weird. I don't think that he's innocent, but I want to know more about the DNA that was in there. You know, I do. I want to know the evidence in the alternate perpetrators, and it's going to be sealed. What will we find out about it? I don't know. But I'm going to go ahead and wrap this one up. Hey, Core, if you guys are on replay, thank you for replaying. And thank you, mods, for being here. I'm going to be live on the other channel shortly if you guys want to join me over there. I'll see you guys in a little bit. Let's run our credits and thank everybody that joined today and supported the channel. Until the next one, stay safe. I'll see you guys. Bye. Thank you so much for watching. If you enjoyed this live stream or video, make sure to give it a thumbs up and hit that subscribe button so you don't miss out on my latest content. Want to take it a step further? Bring it all in. And join our community clickers by becoming a Patreon or a YouTube member. You'll get exclusive access to our Discord server, special channel perks, and much more. Until then, I'll see you in the next one.
Click. It's real easy, man.